This new speaker series is the result of a conversation which started at the Civil Law section a few years ago about the present and future of legal research and legal education, and which led, among other things, to a seminar organized by my colleagues Julie Paquin and Sophie Thériault at the annual meeting of ACFAS last May, around the 30th anniversary of the Arthur's Report, Law and Learning. So we are very pleased to have him today to launch this series. And the objectives pursued by this group that we formed last spring to discuss the connections of legal research and education with science, with the legal profession, and with social change also fit beautifully with the objectives of the social justice group of the common law section. And they are co-sponsoring the event today, and we're very grateful for that and thank them for being here. Et comme ça suffisait pas, eh bien on a aussi les gens à Montréal, nos collègues du département des sciences juridiques de l'UQAM qui se joignent à nous, qui ne voulaient pas manquer ça. Donc je remercie Lucie Lamarche d'avoir mis ça sur pied à partir de Montréal. Our colleagues at UQAM have a very special connection with Harry Arthurs, given the influence of his work on the creation and development of sciences juridiques at UQAM. So now turning to our guest, I have the pleasure and privilege of introducing Harry Arthurs. He is University Professor Emeritus, former Dean of Osgoode Law School, and former President of York University. He has received honorary degrees from a number of Canadian universities. I think I've counted 9, but I may have missed 1 or 2. He has published extensively in the fields of legal education and the legal profession, legal history and legal theory, labor and administrative law, globalization, and constitutionalism. Professor Arthurs has conducted inquiries and reviews at Canadian, British, and American universities, provided advice to governments on issues ranging from higher education policy to the Constitution to labor and employment law. Most recently, he has chaired reviews of federal labor standards legislation and the funding of Ontario's workplace safety and insurance system. Professor Arthurs' contributions have been recognized by several institutions, including as an associate of the Canadian Institute for Advanced Research, a fellow of the Royal Society of Canada, and a corresponding fellow of the British Academy. He's been awarded the Killam Prize for his lifetime contributions to the social sciences. So please welcome Professor Harry Arthurs.
Thank you so much for inviting me to speak about one of my favorite subjects, and to speak not in one city, but in 2 cities, to my friends and colleagues at UQAM, as well as the University of Ottawa. I don't think I have ever had the privilege of being in 2 cities at the same time. So this is a wonderful moment. In the early 1980s, as many of you will know, I was asked to chair what was called the Consultative Group on Research and Education in Law, set up by the Social Sciences and Humanities Research Council, but also by the Canadian Law Deans and the Canadian Association of Law Teachers. Our report, called Law and Learning, was issued in 1983. The original mandate of this group, leading to the report, was to explain why so few legal scholars applied to the SSHRC for funding. In 1979, the year that this project was conceived, only 2 legal scholars applied to the SSHRC, which at the time, I assure you, was much more generous in handing out grants than it is today. So this was a mystery. Why didn't legal scholars seek funding for their research? Answering that question took myself and my colleagues on a long march through what we came to see as the wastelands of legal scholarship and education. And it prompted some critical observations about the intellectual formation of legal scholars, about their teaching and research, about the way in which law students and lawyers reacted to the legal academy's understanding of what law is and what law does. And then last year, 30 years later, a colleague of mine at York, Annie Bunting, and I were asked by the British Journal of Law and Society to write a report on the state of socio-legal research in Canada. It's the first of what will be a series of national reports that will appear in that journal. We've recently completed our work. We're happy to share with you some of our preliminary results. If anyone hasn't seen them, they're all, I think, posted online. They're available for you to look at your convenience. But I want to warn you, before I begin to share my results, I want to warn you of two things. Take these warnings very seriously. The first is, please be careful how you read our article. We had some difficulty in deciding what socio-legal scholarship was and what it wasn't. Our methodology wasn't perfect, and though it was the best we could manage with our limited resources, our data aren't as comprehensive or as reliable as the data in Law and Learning 30 years ago, which was our point of comparison. So that's the first warning. Second warning, even more important. When I'm finished sharing with you the results of our survey, I'm going to get very angry. So if you're a sensitive person, put your fingers in your ears. All right? You've got my warnings. So first of all, our findings. Our conclusions are, in fact, encouraging for anyone who believes that there should be room for approaches to legal scholarship other than doctrinal analysis. There is, in fact, as we've demonstrated, a 30-year trend to increasing diversity in the methodology used by legal authors publishing in law journals. Most of them, I say legal authors, most of them are legal academics, but of course there will also be a number who are social scientists, not trained in law, but writing about law. I have to tell you that a year or two before we did our survey, Connie Backhouse and Rod MacDonald, writing in the Canadian Journal of Law and Society, were skeptical about whether scholarship in Canadian law faculties had changed since 1983. Our conclusions, unlike theirs, I may say, are supported by empirical research. We actually went out and counted what was being published. We and our research team, a little team, looked at some, I think, 1,100 articles before reaching our conclusions. I've already confessed the methodology wasn't perfect, but I think our conclusions can broadly be defended. So I'm going to simply refer to the fact that over the last 30 years, there's been year by year a gradual increase in non-doctrinal scholarship, let me put it that way, much of which I would have to describe as socio-legal, to the point where now almost half of what's published in Canadian legal journals in French and in English, almost half, is non-doctrinal. Of course, there are many other places where people publish doctrinal scholarship, and I'll say a word about that in a moment. But first, I want to speculate on why that trend, that upward trend from 1983 to the present, has taken place. I want to then step back from the numbers, step back from the statistics, and offer you some thoughts about what the future might hold. I will conclude with a brief obituary of Canadian socio-legal scholarship. So, I've mentioned the basic numbers. I think it now stands at about 45–46% of what's published in law journals across the country in both languages. About 46% of that is non-doctrinal. But let me add some additional evidence to support the conclusion that socio-legal scholarship has done relatively well over the last 30 years. First of all, there's been an enormous expansion in graduate education in law, and consequently, I think, in the proportion of legal academics with doctorates, and also, we think, the evidence is not quite clear, an increase in the proportion of law teachers who've done graduate work in other disciplines. A good deal of the graduate work that's gone on, we've looked at the title of doctoral theses and so on, a good deal of the work that's gone on at the doctoral level involves legal history and legal theory and other interdisciplinary perspectives. And very importantly, there's been a huge expansion of law and society programs outside of law faculties. The first of those programs, I think, was at your neighboring university, Carleton University. York came fairly early to the field. UQAM was a pioneer, I think, in Quebec. So there's been a great expansion of teaching and scholarship about law outside of law faculties. Funding for socio-legal research has also grown considerably, partly because people are asking for it. I assure you, in 1979, when only 2 people applied, the SSHRC didn't send people letters and say, please apply, we have money for you, the check is waiting. That did not happen. As more people applied, it became clear that there was a huge opportunity for scholars to do serious work in an interdisciplinary vein in and around law. Just to give you one number, it's not very impressive perhaps, but though only 2 people applied for SSHRC funding in 1979, some almost 50 people applied in 2012. So there is a significant expansion, but when you consider that there are over 1,000 people teaching in law faculties, never mind those in socio-legal departments, the number is perhaps not as large as it might be. However, in addition to SSHRC funding, significant funding for socio-legal research comes from law reform commissions. This fluctuates as governments like or dislike the idea of law reform, but nonetheless, it's an important source of funding. So too, inquiries like the Royal Commission on Aboriginal Peoples, which did a great deal of socio-legal research. And even some funding comes today from law firms that finance research designed to produce or to support expert evidence in charter litigation. I want to mention also that since 1983, there's been a huge proliferation of organizations and journals and publishing programs devoted to socio-legal research, ranging from the Canadian Law and Society Association, which dates back to 1984, and its journal, of course. In the legal history field, there's the Osgood Society for Legal History, just to mention a couple of other opportunities. Wes Pugh at the University of British Columbia established some years ago a special publication program in Law and Society, and it's produced from memory, I think, something like 40 or 50 books over some 15 years. University presses, prestigious presses like the University of Toronto Press, now run a significant list of publications about socio-legal themes. And finally, there's been a proliferation of legal research centers and programs, including at my faculty, for example, the Center for Feminist Legal Studies, established in the late 1980s, and your laboratoire de recherche interdisciplinaire sur les droits de l'enfant here at Ottawa. But these are just two examples amongst many of interdisciplinary research programs that exist in faculties across the country. So to sum up, there's been a considerable increase in the number of Canadian scholars doing socio-legal research. There's been an improvement of institutional infrastructure, and all of this has been supported by grants and contracts and of places to publish the output of the people that are doing this research. I'm going to offer one suggestion which is unsupported by any hard evidence, but it's just an intuition. I think that socio-legal research has gained less acceptance from practitioners and judges than it has in legal academic circles and in places where public policy, where legal policy is made. I think the cutting edge of the bar, the hard edge, the edge that makes the money, has not yet embraced the idea of socio-legal research as much as other domains within the field of law. And I'm sorry to say, to take that thought even further, I'm sorry to say that most importantly for law faculties, the governing bodies of the legal profession seem particularly indifferent or hostile to using socio-legal studies to discharge their mandate of regulating the profession and legal education. I've written several things lately on this. You can tell I'm winding up to my rant. I'm starting to get angry, so remember if it gets too much for you. I've written several things. They're posted again on, I think, on the website here. But I want to underline that the antipathy of the bar, particularly to socio-legal research, is manifest in the fact that in creating very important and, in my view, wrong-headed rules for the regulation of law schools, they did literally no socio-legal research. And belatedly, as I'll explain, when they did a little bit, they did a very bad job of it. I'll explain all that in a moment. I want to stick with the history for a moment, however. I certainly don't believe that it was law and learning that triggered this expansion that's gone on for the last 30 years. The trend I'm describing began well before 1983. It's evident elsewhere in the legal academies of other countries where there was no equivalent of law and learning. In my view, the expansion of socio-legal research was part of a long historical process of law's development as an intellectual discipline, at arm's length from and often in opposition to law in its various professional incarnations. Moreover, there are parallels between law and other academic disciplines that have a professional relevant other, including medicine and business and architecture and education, all of which have developed or are developing an interdisciplinary knowledge base. So the most I think I can claim for law and learning is that it documented and explained, and I hope legitimated, the trend that began before 1983 and has continued since. And now a key point. Socio-legal research in Canada began to move forward precisely at the moment in the 1960s when the profession's control and influence over legal education began to recede. Was this a mere coincidence? I think not. In the 1960s, law faculties finally came to be dominated by full-time academics rather than part-time practitioners. Faculty recruitment criteria, resource deployment, reward structures began to respond to academic norms and practices as well as to professional training priorities. The critical mass of researchers grew exponentially. Their skill sets diversified considerably, and research agendas predictably began to diverge from that of the practicing bar. Again, I don't want to overstate my case. In 1983, and still today, Canadian law professors tend to do more doctrinal research than any other kind of research. In fact, it's important to recall that the rise of socio-legal research coincided with an upsurge in the quantity and quality of doctrinal research. Remember, until the 1970s and really into the 1980s, there were few comprehensive treatises on any aspect of Canadian law. There wasn't a treatise until my colleague Peter Hogg produced his on constitutional law at the end of the 70s, until another colleague, John McCamus, produced his treatise on contracts. There had only been one book on the subject written, and that was 50 years old at the time. So there was a great explosion, not just of socio-legal research, but of doctrinal research, not just of research of interest to the academy, but research which was, one would have thought, essential for the day-to-day practice of law. So the good news is that socio-legal research began to flourish in the 1960s, and now, alas, the bad news, the obituary, the rant. I'm afraid that 50 years of progress may be over, and that things from here on are likely to head in the opposite direction. My assessment is based on developments in the common law provinces, but I would be surprised if Quebec took a different course. My colleagues at UQAM will recall their encounter with the Bar of Quebec when UQAM decided bravely to start out in a different direction than other law faculties. The rapidity with which the Barreau de Quebec suppressed their experiment was astonishing. And I'm sorry to say that I fear we're about to witness similar repression by the bars of the common law provinces today. The most important development is, of course, the unprecedented decision of the Federation of Law Societies to tell law schools what they must teach. Again, I document it in a paper that's on record on the website. Unfortunately, most of Canada's law deans didn't push back against what, in my view, and I modify my language as much as possible. They didn't push back against what was a supremely stupid decision by the law societies to intervene in the academic affairs of Canada's law faculties. At the same time as they're intervening in law faculties, law societies are attempting to download the task of practical training onto the law schools. Practical training which they found inconvenient, expensive, and for which they weren't properly thanked by the people that they were training, mostly because the training wasn't very good. So, they're abandoning their historical role, gradually shifting it to the law schools, and this is changing the whole dynamic of legal education, and I'm going to argue the dynamic of legal scholarship as well. As I've already signaled, I'm very much opposed to this development, but not all legal educators are opposed, and indeed some are quite enthusiastic about the prospects it offers them. In this regard, I cite particularly the brand new law school at Lakehead University in Northern Ontario, which has, as I'll explain, in my view, radically degraded the environment for legal scholarship at that law school, and similar developments elsewhere, I think, will similarly degrade the environment in which legal scholars hope to work, especially on socio-legal research. The core assumption of the new law society regulations is that law faculties exist primarily to supply graduates who are practice ready. They can walk out our doors and they will be ready to serve clients. In order to be practice ready, says the law societies, they must possess certain competencies, that's their word, and knowledge of certain specified subjects, quite a long list. However, the way in which the Federation reached this radical conclusion in itself conveyed a strong message that for our governing bodies, policy doesn't depend on facts. Not a single shred of evidence was offered in the report leading up to these regulations. Not a single shred of evidence was offered to demonstrate the need for these new regulations or to justify the massive derangement that the new regulations will have on law faculties across the country. Nor could any evidence have been offered because no evidence exists. Nobody knows what makes a lawyer practice ready. Nobody knows today what lawyers do. No one knows what books they read, what skills they deploy, how much time they spend on one field rather than another field. Nobody knows. And to take the radical step that the Federation of Law Societies took to dramatically alter the landscape of legal education, the environment of legal education, I think is a terrible indictment of the law societies and radically undermines any credibility that their new regulations might have. But the story gets even worse. As I mentioned a moment ago, about 2 years after issuing a report on legal education and adopting new requirements for law schools, 2 years later, the Federation of Law Societies undertook what they called a validation study. So if you unpack the word validation, it means the following. We have reached our conclusions. We will now go out and see if we can find some evidence to support them, which is precisely what they did. They sat down and drew up a list of all of the things they thought young lawyers might do in their first 5 years of practice. And then they went around and found, did a survey in which, by the way, the rate of return was too low to be statistically valid. They did a survey of young practitioners, and they said to them, have you done any of the following things? Tick a box. And then they said to them, if you have you done it once a day, once a week, once a month, less than once a month? And then they said, if you add up all the ticks in all the boxes, and 20% of the respondents, remember, an inadequate response, but put that aside, if 20% of the respondents ticked any of the boxes, then law schools will be required to ensure, sorry, that's not quite right, people coming to the bar will be required to possess the following competencies. Think of it for a moment. One of those boxes is less than once a month. Okay? So that could be every 2 months, every 6 months, every 5 years, once in a lifetime. And based on that evidence, every lawyer called to the bar in common law jurisdictions will be required to study and to demonstrate competence in that particular kind of activity. So is it progress or not progress to go from no empirical evidence to faulty empirical evidence? Are they on a trajectory? Will they do a post-validation study which improves the methodology? But most important, will they change the trajectory on which they have now launched law schools? So I come now to dealing with that question. Will the Law Society retreat? Will it alter the detailed prescriptions that it has foisted on Canada's common law schools and is likely to foist on Quebec's law schools in due course? In my view, I think we're only at the beginning of law school intrusion into the affairs of the legal academy. If I were reaching for a metaphor, the first words that come from my mouth would be the Ukraine. All right? Do we believe that Vladimir Putin will content himself with annexing Crimea to Russia? Hands up, everybody that believes it, because you are also the people that believe that the present intrusion of the law societies into the domain of legal education is all that's going to happen, that there will be no further intrusions. Why will there be intrusions? The law society's claim is that it's necessary to ensure that young lawyers are practice ready in order to protect the public from incompetent service by young lawyers. that indeed is their business. So, how vigilant have our law societies been in protecting the public from incompetence? As I cite in one of my papers, there are some 85,000 people licensed to practice law in Canada. When you review the published decisions of discipline committees set up by the law societies, whose mandate includes punishment for incompetence, removal from practice for incompetence. In a 2-year period, 2012 and 13, in a 2-year period, I won't go through the detailed statistics, essentially 2 people out of 84,000 were disciplined for incompetence, neither of them for incompetence that was in any way related to the list of things that law schools are now required to ensure that graduating students have been instructed in. So, what conclusions do we draw? Do we draw the conclusion that the claim that this intrusion is necessary to protect the public from incompetence, that this is a claim made in good faith? Or do we claim that it's an exercise in power? It's an exercise in control. That it's driven not by evidence, not by a sincere desire to protect the public. Its desired aim is only to get hold of the law schools and keep them doing what they have begun to do over the last 40 or 50 years, and especially from the early 80s onward. So, first of all, why is that such a bad thing? And second of all, why is it happening? It's a bad thing because this new requirement, the new requirements that the law societies are imposing on common law schools, the new requirements require a redeployment of the resources of law schools. Acquiring competencies, negotiating skills, advocacy skills, drafting skills, those are resource-intensive teaching requirements. You can't teach drafting or negotiating or advocacy to a class of this size. You need a very much reduced ratio of instructors to students. How do you achieve that ratio? Well, if you're very wealthy, you go out and you hire a bunch of clinical instructors, people who will work closely with students to educate them in skills. And by the way, Lakehead University that I mentioned has said very openly that is what they're going to do. They've said they are reducing the academic program, first of all, from 3 years, essentially to 2.5 years. That large parts of the 2.5 years, plus the last 6 months of the program, will be given over to the teaching of practical skills. And that those skills will be delivered by people hired on short-term contracts with only teaching responsibilities. So what Lakehead has done may make sense in the peculiar circumstances that they operate in of a remote community in northern Ontario. But what they've done is they've shown us what the future of law faculties is going to look like. Either law schools will begin to be staffed by short-term people, presumably with some ability to teach students competencies, or the existing faculties, faculty members, the professoriate, as they retire, will not be replaced. As they go through their careers, teaching what the Law Society requires will be rewarded, and spending time on socio-legal research and other frills will be punished. And that's what concerns me deeply. I think a hostile atmosphere has been created which will make it extraordinarily difficult for people to persevere with their intellectual interests. Why is this coming about? Why is the Law Society exerting its control at this particular juncture in history? Not because, as I've already said, there's any demonstrated need to protect the public from incompetence, at least on the basis of the Law Society's own inaction, which speaks to the absence of a problem. But the legal profession is in turmoil. It's in turmoil because the legal services market is collapsing due to changes in the economy, due to information technology, due to a number of other causes having nothing to do with law faculties. The legal services market is changing. We hear much talk, and by the way, a lot of it emanates from the United States, but we hear much talk about there being too many lawyers, though clearly there are hundreds of thousands, if not millions, of Canadians who need legal services and don't have access to them. What's really happened is that the restructuring of the Canadian economy under pressure of globalization, under pressure of neoliberal policies, deregulation of markets, and so on, the demand for the services of large corporate law firms has been undermined. New competitors have appeared in that part of the legal services market, principally the sort of firm whose name graces this classroom, global law firms, who now service abroad Canadian corporations which used to be serviced on Rue Saint-Jacques or on Bay Street. So there's turmoil in the top end of the market for legal services. And at the bottom end, we have online suppliers of do-it-yourself forms so that people can effectively avoid having to hire a lawyer for their own modest, routine legal problems, incorporating a company, whatever. So the legal services market is in turmoil. And it's much easier for the Law Society to blame law schools than it is for them to have anticipated, as any reasonable person would have done. Many people have been writing about this, the impending collapse of the legal services market. It would have been much easier for the Law Society to get hold of that if they had agreed to do some socio-legal research on the issue that concerns them most, which is how their members are going to make a living. But they didn't do that, and they were caught unawares, and they don't know what to do about this crisis. And so the easiest thing to do is to say, lawyers are overeducated, students are paying too much money and can't repay their loans when they graduate, they have no job prospects, and so on. And so to demonstrate their control, they intervened in legal education. And let me close on the following note, not just to demonstrate their control, but to demonstrate their disapproval of the way legal education and scholarship have developed. If you say to people, in law societies. We will not be able to continue our scholarly project if we have to comply with these new regulations. They say, too bad. We think it's very nice that you do all this scholarship, but in the end, what counts is turning out competent young graduates. And if you have to put aside your scholarship, so be it. I take a very different view. Many of you will take a different view of the trade-off that we're going to be forced to make between compliance with the Law Society's regulations and continuation and expansion of the great project of socio-legal scholarship that was launched in the 60s and really came into its own in the 80s. Thank you very much for coming. I'd be happy to have a conversation about some of these ideas. Thank you.
So thank you very much. We'll start the question periods. Many things have come up, so if you have any questions, please go ahead. We have also our colleagues at UQAM. I don't really know how I'm supposed to monitor the question period with them, but anyone wants to kick off the question period?
I'm really fascinated by the idea that the Federation of Law Societies is supposed to be our biggest problem. It seems that many of the things you talk about are also exerting pressures on public education much more broadly. And some of those neoliberal pressures or pressures of casualization, professionalization also affect our colleagues across faculties. In some instances, that generates actually counter pressures, doesn't it? It generates, for example, pressures for external funding to be generated. So a disappearance of legal scholarship that seeks external funding in fact forces particularly junior faculty into grant seeking as a primary occupation. It doesn't seem to me to be reconcilable with this latehead vision.
Just before you answer, I'm supposed to repeat the question to the people in Montreal. I'm not sure I'll be able to repeat everything, but basically it's about the pressure that's put on junior faculty and faculty in general to engage in grant writing and the pressure put by the university.
As you know, and I think as you just indicated, external funding is increasingly hard to come by. It's hard to come by on the research side. I'm sorry, do you want me to?
Well,
where would you like me?
If you can just
okay. Sorry. Okay.
As long as you're close to it, it's fine.
Okay. So, in many provinces, Ontario happens to be one of the worst, but in many provinces, funding for higher education in general on a per capita basis is diminishing. At the federal level, funding for research isn't diminishing, it's expanding, but it's being diverted away from the social sciences to the natural sciences, to medicine, engineering, and of course to business. The terms on which funding is being granted increasingly involve partnerships. Partnerships with, let me be honest, many of the very institutions that it is the purpose of socio-legal research to be critical of. So prospects for partnership, I would say, are not particularly good. So there are strong pressures coming from government which militate against socio-legal research. But there are also pressures coming from students. Students, I think, have never quite perceived the the virtues of socio-legal research to the same extent that faculty members have. And as the job market becomes more and more difficult, more and more of them will reach the conclusion that law professors are simply being self-indulgent in pursuing this kind of research, rather than devoting their time to assisting their students to gain the skills that will in turn bring them employment when they graduate. And there's something else that's much more subtle, and it affects both governments and students. I call it, in one of my papers, the new legal fundamentalism, which is part of a broader anti-intellectual movement, which one has only to say Statistics Canada and the statistics long form, the census long form, to catch the mood of what I'm trying to convey, which is we don't need evidence. We don't need to fix problems. And least of all, do we need evidence which will reveal the existence of problems. If you are fundamentally committed to the unseen hand, to the power of spontaneous market transactions to alleviate the ills of the world, you don't see law as an instrument to make the world better, nor do you see socio-legal research as a way to make law's ameliorative potential grow. So there is a kind of general intellectual mood, anti-intellectual mood. An ideological position is subtly developing, which is at odds with the kind of supportive view of socio-legal research that persisted, I think, from the 60s through to about the year 2000, which is a mood in which law, the state, lawyers were seen as instruments for improving the lot of people. So I think that's way down deep, and I can't document this as speculation, but my sense is way down deep. It's not just a matter of money. It's a matter of ideology. It's a matter of antipathy to both the motive and the end product of socio-legal research.
David?
Harry, in one of your papers, and you touched on this a little bit, you identify that maybe what we need to be afraid of here is that so many students graduated from law schools, ended up running law societies, and now have decided that law schools, need to be recontrolled. So did we miss the boat somehow in that whilst we were doing all the socio-legal research, we weren't sort of embedding it in the curriculum or legal education enough such that we didn't sell anyone who ultimately is now in authority on why that's a good way to go? Or is it that they get it but they've got other priorities now? Or
I'll just repeat the question for Montréal. Alors, est-ce qu'on a manqué notre coup parce que finalement, c'est nos étudiants qui maintenant occupent des positions au sein des barreaux et qui ont voté ces nouvelles résolutions?
So, I think I'll begin a little before your question begins by saying the following. If you believe that the function of law schools is to teach law students, then the phenomenon of students turning against their own education is, what shall I say, normal in the evolution of relations between students and teachers, children and parents. There's a general, a generational resistance to replicating what has gone before, a determination to do better, to do different. My contention is that training law students, training future lawyers, is a distinct enterprise, obviously legitimate and important for law schools, but a distinct enterprise from their function as sources of understanding about law and critique of law. That the scholarly enterprise is not just a byproduct of our role as teaching. If anything, the reverse. Teaching is a byproduct of our scholarly work. Students may well resent that, and therefore resent the scholarship that we push at them. But I don't think we should be apologizing for doing the thing that only we can do. Only we can do it. Only we are the source of independent, broadly based, critical writing about law and its effect on society. So I think part of the phenomenon that you identify has to do with a failure on the part of our graduates, I think to some extent on the part of ourselves, certainly on the part of law societies, a failure to understand that scholarship is a freestanding enterprise. And it's not what you do with the few hours that you have left over after you're finished marking your exams. And that was a message, I hope, that was sent in Law and Learning. I don't think it was very well received. And it's a message that if I were a dean today, I would frankly have trouble with. Because where's the money? Where's the resources? How do I support scholarship as a freestanding enterprise? How do I say to somebody who's spending 10 hours a week in the classroom, be more productive in your scholarship? Am I prepared to take away some of those classroom hours to make good on that aspect of the person's functions? It's not easy to do that. So what this attempt to establish scholarship, especially socio-legal scholarship, as a freestanding enterprise, separate from teaching, engenders some of the hostility that you identify. But that in turn creates a whole lot of pressures within law faculties, as well as pressures coming from outside law faculties about how you deploy your resources and how much priority you give to one function rather than the other function, or in the most benign view of the matter, how you have the two functions support each other.
J'ai Catherine, et s'il y a des gens à l'UQAM qui ont des questions aussi, vous pouvez peut-être lever votre main que je vous vois.
Harry, thanks. It's always wonderful to really know why we are correcting being depressed. And as I said, with perfect solidarity. I have a comment that came out of reading your paper, and I would like to try and link it up and make it into a question for in light of what you presented. And I was, the paper I'm talking about is the one on socio-legal scholarship that counts the number of articles. And you mentioned in terms of methodology that it's not perfect, and I hear that. My first reaction, because you have the table at the end, and you have the French scholarship and the English scholarship, and the English scholarship has gone up and up and up, and the French scholarship is stagnant, essentially. It's not stagnant, but it hasn't gone up and up and up. If anything, it's
No, they both end up at about the same place over 30 years.
And when I was reading it last night, and I was, you know, I come from UCAM, those are my people, and I was saying, but we're all writing like there's no tomorrow, so where are we? And then where we are is not in the legal literature. And perhaps because we were so inspired in '83 and '84 when your studies came out, we embedded interdisciplinary research teams, and if you want to look at law as a legal variable, perhaps the first place you're going to publish is not in the law journal. You're going to publish in a journal of criminology, or you're going to publish, you know, if you're doing something on experience rating, you're not going to put it in the McGill Journal of Law and Health. You're going to do it somewhere where the people who make those policies can see your critique. And I have no idea whether in the French literature that's more common that people are publishing elsewhere than in the legal literature. It's certainly true of me personally, is I'm not publishing in the legal literature very much. But, so here's my question, is basically the evolution of thought, and it's socio-legal thought, it's just where's your output going? People who are embedding themselves in interdisciplinary teams that are lined up to change things and make things better. If I hear you, and I'm afraid that I agree with you, if the law societies are really going to control the possibility of having that kind of intellectual scholarship, what they're really doing is closing the doors for highly skilled intellectuals who understand the law and who can work outside of the practice of law in the analysis of law. So I don't know if you can comment on that. But,
We certainly conclude in our... I'm sorry,
Repeat the
please.
question, if I can, because that was quite long. En fait, concernant les forums de publication, que beaucoup de gens qui font du socio-legal scholarship vont publier dans des revues qui ne sont pas nécessairement des revues juridiques. Et essentiellement, est-ce que le fait que les barreaux aient mis, contrôler la profession juridique, pas la profession juridique, mais l'éducation juridique va avoir pour effet que les gens qui sont dans les facultés de droit, mener à l'exode des gens des facultés de droit.
on ne veut pas pouvoir cultiver une culture qui permet ce type de pratique.
C'est ça, ne permettra pas ce type de culture au sein des facultés de droit.
Just to speak to the data first, we tried to see if leading social science journals experienced a significant increase in articles about law, which they didn't. There clearly are some new journals, most obvious one, the Canadian Journal of Law and Society, which for some time, as we both know, was located at UQAM. There are some new outlets for socio-legal scholarship. And the reason that those outlets have emerged, I think, in large measure, is because there's a new constituency of socio-legal scholars not located in law schools, who are located in law and society programs or sociology or political science programs. One obvious outlet, which somewhat augments the statistics in conventional law journals, is these specialized journals that cater for socio-legal scholarship, either in a general way like the Canadian Journal, or specific topics, feminism, or several other journals where the writing is very often socio-legal. Other outlets, I think, which are very important to note, is the growth of books as opposed to journal articles. Again, law journals in particular are not very congenial if you're doing a lot of empirical work, if you're doing ethnographic work. The size of a conventional law review article, 30 pages, whatever, is often not appropriate for conveying the output of scholarship, which is genuinely interdisciplinary. So I think that partly explains the success of Westpue's publications, the expansion in other university presses of their list of legal and socio-legal publications. And a lot of it is finding its way into those publications. But just to conclude, and I think we agree with each other, our almost last word in the article that I'm speaking to was socio-legal scholarship has a better chance of surviving outside of law faculties than inside it. And I take that to be implicit in your question too.
And the corollary is that if you believe that being in a law faculty allows you to have a more specialized understanding of the law, I agree with you in your conclusion, but it means socially this is not ideal because the quality of the understanding of law might be slightly more superficial if people are embedded elsewhere than in a law faculty.
Let me just recapitulate for the benefit of our friends. Does doing your scholarship in the context of a law faculty mean that you come at the problems with a greater understanding of law? And I think you're shaking your head, I would shake my head. I think not. I think you're subject, of course, to déformation professionnelle, but what advantage you do gain from being in the law faculty is the following. Number one, money. Number two, prestige. Number three, by and large, better working conditions. And number four, critical point, greater access to people who make decisions, whether they're in government ministries or sitting on the bench. Your credibility with that particular audience may be enhanced by the fact that you come from a law school. When we were doing law and learning, I remember we would go from city to city and have hearings to which people would be invited. And in Toronto, we invited, amongst other people, a very, very progressive practitioner who was also a member of the Law Society, a governor of the Law Society. And here is what he said. He said, I will read anything, absolutely anything written by a law professor. But he said, I will never read a word written by some goddamn sociologist. Right? And it's such an unpleasant and stupid position. And yet it's a position so characteristic even of young and progressive activist lawyers.
We only have like 3 or 4 minutes left. If there are questions, perhaps we can group them. Oui?
I would just like to know what are your recommendations to combine like social legal studies and then one of the mission of Faculty of Law, which is to teach future lawyers, because for me that appears to me that the vast majority of students will become lawyers and will become social legal researchers. And what do you recommend? I mean, because at some point I feel it's not even compatible. I mean, in one of my master, at the end of the master, I didn't feel I wanted to go in a law firm, and some of my colleagues just dropped law. I mean, they're starting to do photography, linked to law sometimes, but you know, they just drop it because we learn new ways of thinking, and so we were more focused on mediation, for instance, and not working in law firms. So how do you make a compliment? And just a small comment, like to different students, fellow students, because at the PhD level, we are very free, and I'm really enjoying doing social legal studies at the PhD level, especially in the University of Ottawa. But then, when I will get back to my country, I have to be like very careful, because if I want to be hired as a lawyer, only in the university, I have to show I'm a good lawyer. Otherwise, I won't get a job, because there is no job for the kind of stuff I learned until there. So sometimes, you know, I feel professors encourage us to do social legal studies, but then when we want to get a job, we cannot. And then when you look at their curriculum, in fact, these professors started to be like really good lawyers, very traditional, very classical lawyers, and then at a point in their career, they started to do social legal studies, and then teaching us in masters. But then I feel like the university, at least in France, is not ready for PhD students like us. I mean, for a few of them.
Alors, rapidement, des recommandations pour réconcilier la schizophrénie des études supérieures dans la tradition socio-juridique et le fait qu'il faut être un avocat pour être embauché.
So you ask a very hard question, but forgive me if I start by correcting one point. The vast majority of people do not go out to practice law. Okay? There are 85,000 people licensed to practice law. A third of them are not practicing in the conventional sense. And in addition, there are many people who graduate from law school who do not go on to be licensed. So it's not a vast majority. Probably 60% of people who take law degrees end up in legal practice in the conventional sense, number one. Number two, of those people who are practicing law in a conventional sense, as much as we know about what they do, they are not practicing law. Okay? That is to say, they are processing legal documents. Okay? They are performing high-grade clerical functions, adhering to routines which they cannot afford to depart from because they cannot charge clients to practice law, which explains why so much work in law offices is delegated to people that are not licensed to practice law, and why so much of the time of people who are licensed is spent supervising what we call paralegals to do routine tasks using, what shall I call it, frozen law, encapsulated law, which at some point somebody has analyzed and incorporated into a precedent, a form, a process, and it's the only efficient way to deliver legal services. So a significant element of that 60% of our graduates could as easily have been qualified as paralegals with no loss to the public and probably a great gain. What this doesn't speak to is the existential problem that you represent in your own life, which is people with intellectual ambitions and social commitment pursue the opportunities for advanced study and for broad legal education that we offer them. And then what do they do with themselves? So obviously, in an era of activist government, more of them will be drawn into government-related work, either for the government or against the government. More of them will be drawn into long-term inquiries, commissions, that sort of work. I found something very interesting. I looked at the website of one of the world's largest consulting firms. And what they said under the title Employment was, we don't care what you studied at university. We have people here who studied classics, who studied music, who studied obviously business and sociology and economics and law and everything else. What we care about is that you have the intelligence and the analytical capacity and the intellectual curiosity to engage with the complex problems that we encounter. And to the extent that the legal profession remains a player in the resolution of complex problems, that's what's going to be needed. And the rest of the stuff will go to computers, and it will go to paralegals, and there will be, in law as everywhere else, good jobs and bad jobs, and people like you who are well-educated and intellectually ambitious will get the good jobs.
So we're a little bit pressed in time. I have to stop, but thank you very, very much for this very thoughtful reflection, and we hope to continue the conversation.